My name is Chen. I am an associate professor at the University of Ottawa's Faculty of Law, and I currently hold the Dean's Research Professorship in Migrant Health Equity. My research generally examines legal and policy issues that emerge at the intersection between health and international migration, or what I call migration health law. And so today's topic is really uh, right up my alley, but it's something that I'm also very passionate about. I'm very pleased to welcome you to today's webinar on medical inadmissibility, disability rights, and migrant health. I will be taking on a dual role today, first as moderator and later on as one of the panelists. Medical inadmissibility, specifically the idea that newcomers may place an excessive demand on health and social services, has, as you will hear today, arguably been a fixture of Canadian immigration law for a very long time, with roots that stretch back even to the pre-Confederation period. Yet, despite this long history, it seems to be a policy that is relatively little known to the broader public. And so, one of our hopes today is that this webinar can contribute in even some small way to greater public awareness and understanding of this issue. But perhaps even more importantly, we hope that those of you who are joining us today will take part in the discussions during the Q&A. Our goal is not only to examine the policy as it currently stands, but we hope that collectively we can start to think about the policy's future. And so what may take to move beyond this excessive demand framework, and how can we work together towards the eventual repeal of what many have long regarded as a discriminatory policy. And so, in that spirit, please allow me to briefly introduce you to the rest of the panelists in the order that they will appear today. So I figure I'll just introduce them all at once, and then we can just get going with the panel. So first up, we have Anne-Rachelle Boulanger, a lawyer working at the intersection of migration, health, and human rights. So she holds graduate degrees from both the University of Toronto and Cambridge, and is currently a policy analyst at the HIV Legal Network, where she leads immigration advocacy, including efforts to challenge Canada's medical inadmissibility laws. She also works on areas relating to youth access to healthcare, harm reduction in prison, and equitable access to shelter and housing. And previously, she served as a research fellow with the Global Detention Project and consulted for the United Nations. Next, we will hear from Valentina Capurri. She was born in Italy, and Valentina came to Canada in 2001 as an international student. She now holds a master's degree in geography and PhD in history, both from York University. Her research interests lie in geopolitics, citizenship and identity, urban geography, immigration, as well as disability studies, specifically within the Canadian context. Notably, she's the author of a book published in 2020 titled Not Good Enough for Canada, Canadian Public Discourse Around Issues of Inadmissibility for Potential Immigrants with Diseases and or Disabilities from 1902 to 2002. And following Valentina, we will hear from Laura Bisaillon. Laura is a sociologist whose scholarship focuses on unearthing invisible histories and institutional stories in Canada. A bilingual scholar of Canadian immigration and associate professor at the University of Toronto, her research explores the confluence of law, medicine, governance, and daily lives in Canada, specifically by connecting medical diagnosis, disability, migration status in entirely new ways. She has forged a new scholarly field, what she describes as the medical legal bureaucratic borderlands. And she has written 2 books and a plethora of peer-reviewed articles, which have been sources of sustained public engagement and legal advocacy And she now also serves as the co-president of the Canadian Studies Network and a member of the editorial board of the Journal of Canadian Studies. All right, so those are our fabulous panelists, and you'll get to hear them very soon. Before we get to today's talk, I just have two quick housekeeping matters to address. One is, as we go along, if you have any questions or comments about the speaker's presentation, please feel free to put them in the comment section, and we will try to address as many of them as possible during the Q&A. Okay. And then also, I will soon put a link in the comment section. That is a link to a survey. So please take a moment to fill out the survey after today's event. It will help us greatly to understand how we've done today and how our webinars can better meet your needs in the future. Okay. So with those two housekeeping in mind, I'm going to pass the microphone to Anne-Rachelle, who's going to quickly give us an overview of the medical inadmissibility regime here in Canada.
Awesome. Thank you, YY. Just going to share my screen here. Yeah, we thought it would be useful to start with a just brief overview of what we're talking about today to make sure we're all starting from a similar understanding. So today we're focused on excessive demand, which is a form of medical inadmissibility in Canada's Immigration and Refugee Protection Act, which is our main immigration law in Canada. And medical inadmissibility is the basis for finding that a foreign national, so someone who's in Canada who's not a citizen, it's a basis for finding them inadmissible on health grounds. So it's a basis for Canada to say, no, you can't stay, or no, you can't enter because you have a particular health condition. We are focusing on one particular sub-provision of medical inadmissibility, which is excessive demand, which is the government's basis, or the law says it excludes people who might, and now I'm quoting, reasonably be expected to cause excessive demand on health or social services. And in just a moment, I'm going to break that down further. But just for context, nowadays, based on the most recent data I have access to, there are about 200 to 500 people a year who will be denied based on excessive demand. Previously, it was closer to 1,000 or 1,500, and we will discuss why there was that big reduction later on in the presentation. Okay, excessive demand. So again, someone will be refused either to stay in Canada or to come to Canada if the government thinks that their publicly funded healthcare costs or social service costs will exceed this threshold. Every year, the government sets a new cost threshold. It's based on what the government says is the average Canadian's healthcare cost times 3. So the newest threshold is over 144,000 over 5 years, or over 29 or about 29,000 per year of publicly funded healthcare services. Notably, if someone is coming to Canada and they won't have access to publicly funded healthcare services, so if they won't have access to OHIP, then this provision won't be of concern to them. Similarly, if they're coming to Canada, but they know they're going to have access to health insurance through their school, it shouldn't be an issue for them because it's really focused on public healthcare and social services. And nowadays, most HIV medications are not caught by the provision because it is quite high. Folks living with HIV have historically been disproportionately affected by the provision, and they still continue to be disproportionately assessed under the provision, even if not rejected based on the provision. Okay, just a little bit of information on how this works in practice. So, for folks who are coming to Canada, usually for more than 6 months, or for folks who are applying for permanent residence, they have to go through what's called an immigration medical exam. This medical exam has a number of mandatory tests, including an HIV test. The government tries to argue that these tests aren't mandatory. They're done with folks' consent, but the reality is, if someone refuses this test, they won't get their application processed or accepted. So it is, for all intents and purposes, mandatory if someone is serious about coming to or staying in Canada. And the tests are conducted in Canada or all over the world by physicians approved by Immigration and Refugees Citizenship in Canada. And I've just included this chart here of, again, my most recent data on the number of immigration medical exams to give you a sense of just how many people are going through these tests. And I think the 2020 year is a bit wonky, obviously, because we see the pandemic, but you can see how quickly it rises post-pandemic with over 1 million people undergoing these exams. And of course, not all of these people are going to be assessed under the excessive demand provision, but these are all people who could be assessed and who could ultimately be found to be in excessive demand, quote unquote. And with that, I think I'll pass it off to get into the meat of this issue. Thank you.
So, Valentina.
Hello, everyone. Thanks, Anne-Rachelle, for your clear presentation. Gives me kind of like a general framework to start from. My name is Valentina Capurri, and I work on the issues of immigrations and exclusion, also because it's a part of my experience. So when I came to Canada and I did apply to be accepted as permanent resident, I was initially excluded because I have multiple sclerosis. That is a chronic disease that has no cure, and because of this, that kind of generated, as I was fighting with Canadian immigration to get be accepted into the country, generated my interest, and I started to do research to figure out where was this provision coming from and what motivated it. So my study, that YY introduced before, is historical analysis of how medical inadmissibility became such an essential component of the Canadian immigration process. And what I found out is that this provision, as I was mentioning before, has been with us for the longest time. In fact, even the first Immigration Act that was prepared soon after Confederation, so 2 years after, in 1969, there was the first Immigration Act that came into effect, included already these provisions. However, for the first period of time, up until the early 1900s, there was not so much focus on it, and there was not really the number of people excluded based on this category was very minimal, mostly because at that time, before the 1900s, the big bulk of immigration to North America was actually going to the United States, not coming to Canada. It's only with the early 1900s when Canada really, under the Liberal government of Wilfrid Laurier, started to develop a campaign to attract immigrants to the country, that this portion of the immigration legislation became more concerning for two major reasons at the time. That's what I've been able to gather from going through all the public debate that were held in the chamber and also in the Senate. So the major reasons for this rejection initially were, first of all, protect Canada against accusation from the states. kind of similar to today a little bit. Like there was a lot of conflict with what the state was arguing. Like the state was accusing Canada of allowing like disease immigrants to enter the country, and then arguing that these immigrants were not actually staying in Canada, were moving, passing to the United States. So the first reason why like the service got like the issue got under the radar screen of politicians was we have to defend ourselves against accusation from the United States. And another very significant issue at the time was we're just starting as a country. We are just beginning. We need to get our place in the global world. Like we have to show that we are strong, valiant, like healthy, and therefore like accepting like individuals that bring diseases or disabilities was something that was considered unacceptable. So throughout my like analysis of all the exchange that politicians had in parliament in the period from the early 1900s all the way to 2002. I stopped in 2002 because that was when the IRPA was passed, the Immigration and Refugee Protection Act. But like Laura and Anne-Rachelle will like help us understand what happened after that. So my part of the historical analysis, like I was able to identify a certain political rhetoric or narrative that was developed by politicians throughout this period of time that tended to vary a little bit based on the historical context of the moment, but remain relatively constant throughout the whole period in its basic assumptions. And so what I was able to identify are three major phases that like the political discourse developed through. So the first phase is like this one that I just started to discuss when like immigration was perceived as like we need to have to add people that makes this country strong, that makes this country like valiant, like that make this country hardworking. So we have to build from the foundation. And like most of the rhetoric that is developed by politicians, and you can read through the language that they use, is very much like imprinted by like eugenic considerations. So considerations that like people with disabilities are a threat to the national body because they are contaminating the national body. And there is a lot of rhetoric about this that goes through all this phase of development. Something significant though changes in the period after World War II. So World War II signaled kind of a dividing point in the language that is used, if not in the praxis per se, because immigrants with disabilities are still excluded, but mostly in the language that is used. And that's due to a variety of factors. It's due to the fact that after World War II, Canada was trying to reintegrate veterans that had become disabled as a result of the military conflict. So obviously these are people that had sacrificed themselves for the country, like they couldn't easily be dismissed as like contaminating the genetic makeup. The other reason was that like during World War II, Canada had like fought against like Nazism, and after like the war, there was this very strong association that was established between Nazism and eugenics. So the eugenic fortunes also went down the drain, like with the defeat of like Nazi Germany. Also in that sense, like politicians felt kind of like unable to use exactly the same rhetoric when they were discussing the issue in parliament. Another like a point that also constituted a change during this time is that we start to see the beginning of the initial organizations supporting persons with disabilities. So they were not concerned with immigrants per se, but like the emphasis that they gave to the worthiness of persons with disability, to the fact that the persons with disabilities were members of society, definitely forced politicians to somewhat reassess the language that they were using up until that time. The other shift that I notice is like the shift after the passage of the charter, but then I think Anne-Rachelle is going to examine a little more because it indicate a legal aspect. But overall, like my conclusion of my analysis are that this issue of like medical inadmissible immigrants was quite bipartisan. So like all political parties like were on the same page when it came to the need to get rid of persons with like immigrants with disabilities because they were a negative addition to Canada. Now, the rationale for this rejection tended to change to time. As I mentioned at the beginning, was mostly imprinted by like the concern with the contamination to the genetic makeup to the country. Eventually, it became, oh, yes, persons with disabilities are not morally degenerates, are not people that are inherently faulty, but unfortunately, they are unemployable. They cannot be employed. So, like, immigration is something that in this country, in Canada, we use first and foremost to bring like workers that are going to contribute to the country economy. So, obviously, in this frame, it's obvious that if you assess individuals with disabilities as persons that are unproductive, then obviously like the conclusion would be like you cannot let them in because they don't meet the basic criteria that immigrants have to meet to become contributing members of society. After the 60s, throughout the 70s and forwards, there was another spin that changed a little bit, like the rationale was no longer persons with disabilities are unemployable, because at the time, persons with disabilities had been employed. They were organizing to demonstrate that, in fact, they do work and they are absolutely like employable as anyone else. And so the spin changed and say, oh, it's not so much that persons with disabilities are unemployable, but they represent an excessive demand. That was particularly concerning because in 1968, Canada passed Medicaid, so obviously like healthcare became free and accessible for Canadian citizens, and that's when the concern became these people are actually like stealing services that should be made for Canadians or Canadians born. So we cannot allow certain individuals to come in because of the excessive burden that they would represent. And that's exactly what Anne-Rachelle was discussing like at the beginning in her like slides presentation. And is exactly the reason why I was initially rejected from Canada, because the argument was like, it's not that you are unemployable, obviously, like you are employable, and in fact I do work, but the problem is that as a person with a chronic disease that has no cure, multiple sclerosis, this means that eventually you are at risk of posing an excessive cost on like the Canadian health services. And so one way or the other, this provision has been able to sustain itself, to remain. And to me, what is important is like not only how it affects immigrants, because as Anne-Rachelle was saying, actually the number has decreased through the years. She will explain exactly why. But so it's not the number of individuals that are affected that this day is huge, but is more about what it says about the value system of Canadian society and the place that individuals with disabilities have in this society. Because the rhetoric that is developed by politicians seems very much to suggest that, yes, Canadians with disabilities, we accept them because we cannot do anything else. We cannot kick them out of the country. But instead, like those that are not born in Canada, because they are faulty because of their disabilities, they are excludable. They are like people that we can keep out. So it's important to me that we reassess exactly how do we understand disability, and like how do we understand the place that disability has in our society. And hopefully, like Laura, that I'll pass the microphone now to, like, will help us to understand also how this is playing out in the institutional field with doctors and the like. So thank you so much for your attention. Go, Laura.
Grazie. Thank you, Valentina. Thank you, YY, and to Anne-Rachelle and the two technicians that we have in the wings helping us along. And Gilles is going to be helping me with my slide deck. There we go.
Very good.
And it is my pleasure to be among you today. I appreciate this opportunity for education and for conversing and cooperating around change, where changes are needed. Are the slides visible? Yes? Good. Thank you. All right. So my contribution to today's panel is to bring light and order to the chaos and opacity of the Canadian institutional landscape of medicine and immigration and the entanglements associated with these by highlighting forms of immigration health work happening bureaucratically outside of our plain sight. So how do things happen as a means of entering the institutional field to develop understandings and to demystifying how things work institutionally? All right, next slide, please. So I am speaking from my long-term, since 2008, analysis of the Canadian Immigration Medical Program that began at the University of Ottawa, where I completed my PhD, and which culminated in a book published in 2022 called Screening Out: HIV Testing and the Canadian Immigration Experience. And then before that, in 2020, an animated film called The Unmaking of Medical Inadmissibility. All right, next slide, please. The Canadian immigration system includes a medical program which is enacted through the coordinated professional practices of doctors, lawyers, and civil servants. A medical system embedded within an immigration system is uncommon globally. A key part of an immigration application process is the medical examination. This is a mandatory step that occurs outside of Canada for the most part, as Anne-Rachelle's data revealed. Medical examination and the creation of a medical file on applicants are among the highest state priorities. Since the immigration medical system comes alive through the medical file, the role and practices of the immigration doctor are vitally important analytically. As of 2019, there were 2,900 doctors and radiologists worldwide contracted to do medical inadmissibility work. The stakes of negative medical assessment are steep for permanent resident hopefuls. Persons risk being ineligible to remain or settle in Canada depending on test results and medical, legal, and administrative decisions made about them over time. Next slide, please. The Minister of Immigration is responsible for administering the Immigration and Refugee Protection Act. This minister, in turn, delegates people to carry out the day-to-day work of managing and implementing the immigration medical program. Personnel of the Health Management Branch, headquartered in Ottawa, oversee and coordinate this work. The people working in senior positions in this branch are generally medical doctors. The Health Management Branch is divided into 4 sections under the supervision of a Director General. In the Program Management and Control Directorate, employees manage the Interim Federal Health Program and Medical Surveillance Program. The Centralized Services Directorate is where the Health Management Branch's human resources are managed. In the Strategy, Policy, and Communications Directorate, functionaries develop policy regarding the health of prospective immigrants and persons in Canada applying for refugee status. Last is the Operations Directorate, which coordinates the program for immigration medical examinations and manages activities in the regional medical offices where medical files are assessed. The headquarters for the Canadian Immigration Medical Program is in downtown Ottawa, and the other regional medical offices are outside of Canada, in London, Manila, and New Delhi. Employees of the Operations Directorate in Ottawa interact with immigration doctors in all of these countries. The staff in these regional offices are hired locally. On the ground, this practice means that Canadian citizens do not execute the everyday work involved in carrying out the Canadian Immigration Medical Program globally. Medical officers who are trained medical doctors are the people responsible for supervising and auditing the work and workplaces of immigration doctors. Medical officers also prepare training materials that provide the framework for immigration doctors to examine applicants to Canada. Now, how well and how thoroughly and how regularly this work has done has been the focus of sustained attention, exploration, and critique over time. Medical officers in Canada and abroad do the work of medically assessing applicants. Medical officers in Canada and abroad do the work of medically assessing applicants. These officers do not personally interact with applicants, and they communicate with immigration doctors only when they need more information regarding an applicant, such as additional diagnostic results. There are 16 medical officers, to the best of my knowledge, working inside and outside of Canada who do the work of assessing medical files. Immigration doctors send their medical reports to one of the 4 regional offices in the world. So, for example, the medical file for a person in Brazil is processed in Canada, in Ottawa, while that of an applicant in Sudan, for example, is evaluated in the UK, in London. All right, next slide, please. So what you see on the screen here is a drawing that I conceived of and had a designer prepare for you. So what's depicted here are the institutional movements, relationships, and exchanges that I've just explained or begun to explain that I'll delve into here. So the Immigration and Refugee Protection Act and its subsidiary texts, manuals, policies, instructions, guidelines govern the professional and administrative practices experienced by applicants as they enter Canada via the Canadian Border Services Agency, go through a refugee hearing with the Immigration and Refugee Board, apply to the Immigration Department for permanent residency, and are medically organized and coordinated by the Health Management Branch. So in this heuristic, the applicant is depicted standing at the bottom left, and the person is institutionally represented and read as a medical report. This report makes its way through across various people's desks, starting with the immigration doctor, who runs tests, mandatory tests for HIV, tuberculosis, and syphilis, among others at his or her discretion, writes up a file, and then forwards it to the medical officer in the Immigration Department based in one of the department's 4 regional medical offices that I mentioned. The immigration doctor, like the regional medical officer, is mandated to work with applicants within specific understandings and in specific ways. These discursively organized ways of knowing and seeing that we heard so palpably from Valentina, that are socially constructed and have been since the 19th century and up until the present. A senior civil servant with the Health Management Branch explained to me that the branch screens applicants, writes reports on them, and divides their files into normal and abnormal cases. This is how the files are processed. Normal cases, where there are no further inquiry required, are entered into as such in a database. Abnormal cases, including problematic cases, such as a file from a person including Valentina or someone living with HIV or Down syndrome, are forwarded to a medical officer for review. Abnormal or problematic files prompt medical officers to request additional information from applicants or immigration doctors. This is called a furtherance request, which describes both a document and a mandate to do additional bodily analysis on the applicant. A medical file is composed of various forms that the immigration doctor must submit to medical officers. Applicants are organized into the two groups I mentioned, normal and abnormal, and the difference between them is the extent to which the applicant's body will be probed. The forms are stamped accordingly. The immigration doctor uses the form relevant to the person's application category under the Immigration Act. The medical officer working to determine an applicant's inadmissibility renders a medical opinion and sends it to a visa or immigration officer whose job it is to review the entire application file. And this is the person who has the ability to deem an applicant inadmissible under health grounds, the grounds of which Anne-Rachelle enumerated and then will expand upon when she speaks to us next. The visa or immigration officer prepares a letter by working with a standardized narrative text, which is also tailored to suit the applicant's particular circumstances. For example, people with MS, Downs, or HIV will read that this health condition might mean that their immigration application will be declined on the grounds of medical inadmissibility. People are given the opportunity to respond. In this situation, applicants living with HIV, for example, can gather additional medical information about themselves and submit this information. What this information should consist of is not always clear, often is not clear to the applicants and their lawyers. So last slide, please, and I'll conclude. While Canadians would march in the streets if their federal immigration system excluded applicants based on the color of their skin, as it once did, exclusion based on bodily condition persists. New lines of inquiry about medical exclusion are needed to achieve legal repeal. Firstly, we will need to disrupt and transform conventional thinking about people with chronic illness, disability, and genetic otherness, as Valentina intimated. This standpoint can lift us all out of economically predetermined assessment frames. Secondly, we will need to develop counter-narratives that reimagine so-called vulnerabilities stemming from medical and migration statuses. This perspective can produce insights on susceptibility and receptiveness. And so, as my colleagues stated, our collective panel here today is a request for your attention as well as your cooperation. So we would welcome ideas, thoughts you have based on your studies, reflections on what you hear today or your expertise. And if we've missed something, please get in touch with us. Thank you.
Thanks, Laura. Hi again, everyone. Just give me a moment. I'm going to share my screen. Okay. So I'm going to pick up, oh gosh, where's the presenter mode? Okay. So I'm just going to pick up with a few relevant recent developments in the excessive demand regime that occurred at a time in which there was a lot of news around this provision, a lot of quite heartbreaking stories of families being forced to leave Canada after several years, after contributing significantly through taxes, but also socially, culturally, because one of their children was deemed inadmissible because of excessive demand. So this was a moment in which there seemed to be a lot of pressure on the Canadian government to do something. And at the time, the government was still trying to argue that this program was a balanced approach. It was a way to protect our healthcare services, our social services, while also, I think they tried to argue that it wasn't discriminatory. They were just looking at costs. So around that time, the House of Commons Standing Committee, or a House of Commons Standing Committee, undertook a study of the provision. They had input from government officials, from all of the territories and provinces across Canada, from advocates, from people with lived experience, from scholars. And the House of Commons study concluded that, well, basically, this provision is discriminatory, and it recommended that the government repeal the provision entirely. And it provided the government with a few interim measures that could be taken while it worked towards this ultimate goal of repealing the provision entirely. That included increasing the cost threshold. So at this time, the Minister of Immigration of the time, Minister Hussein, he said, okay, fine. We agree this provision isn't in line with our values. We will work towards repealing it. In the meantime, we're going to enact some of those interim measures to try to lessen the impact of the provision as we figure out this restructuring. So at that time, they decided to triple the excessive demand threshold. So at the beginning of this presentation, we talked about how today the excessive demand threshold is an average Canadian's healthcare cost times 3. It used to be just an average Canadian's healthcare costs. And at the same time, the government also narrowed some of the definitions. So social services used to include special education services, and they removed that from the definition. So it resulted in a huge decrease in the number of people that were being caught by the provision. And actually, I have some stats on that. So in 2021, Immigration, Refugees, Citizenship Canada reported that thanks to this policy change, 85% of those that were now accepted would have been denied under the previous policy. So a quite dramatic change. And I think advocates at the time were happy to see this change and hopeful, given the government's promise to slowly work towards the full repeal. But it kind of led to a loss of momentum. We weren't seeing as many news stories. It wasn't, we weren't seeing those like dramatic stories in the news. Pressure on the government kind of fell away. And it has allowed the government to not follow up on its promises. So 8 years have passed since the government made this promise, and they've made no changes. And in fact, now their statements on the provision is, well, with the tripling of the cost threshold and the redefinition, this provision is fine. It's in line with our values. We don't need to change it anymore. And so I think that's part of why we're so excited to have these opportunities to talk about the provision, because it's still immensely harmful, both to the individuals that have to go through it, but also in the broader messaging that, Canada doesn't value migrants. It doesn't value people with disabilities. So I'll now talk you through the HIV Legal Network's charter challenge to the excessive demand regime, which unfortunately came to an end at the end of last year without a real assessment of the merits. But these arguments are arguments that have not been challenged by the government. And we're still very interested in pursuing this kind of challenge as soon as we can. So in January 2024, the HIV Legal Network and this individual who wants to remain anonymous, so we call him RA, started a charter challenge against the excessive demand regime. RA was an international student in Canada, a person living with HIV. And when he applied to renew his student visa, he was rejected on the basis of excessive demand. So we decided to team up with this person and try to have the whole regime finally erased from our Canadian laws. And we chose to focus our arguments on Section 15 of the Charter. So Section 15 is our equality rights. It reads, every individual is equal before and under the law, and and has the right, sorry, my video was blocking, and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So it's important to note that we have case law that confirms that, for the most part, everyone who's physically present in Canada, regardless of their immigration status, has charter rights. So our laws don't allow discrimination just because we're talking about people who aren't Canadian citizens. And let me just, okay. So the first step in making out this argument is to show that the law creates some kind of distinction based on one of the enumerated grounds or an analogous ground. As you likely saw in the Section 15 wording, one of those grounds is disability. And disability has been interpreted broadly enough to include, of course, it's physical, mental disability, but it's broad enough to include health conditions like HIV. So we argued that, of course, this law creates a distinction based on disability because it can only possibly apply to folks who have health conditions or who have family members who have health conditions or disabilities. And the government has in the past, as I mentioned before, tried to argue that, well, it's not discriminatory. We're just talking about costs. We're not saying people with HIV can't come in. We're saying anyone can come in except if they will cost us XYZ. And our response to that is just that cost isn't neutral. It's sort of like a veil over discrimination, and indirect discrimination is still discrimination. So the second step in our Section 15 arguments was to show that excessive demand imposes burdens on and denies benefits to people with disabilities in a manner that exacerbates disadvantage. So for this step, it was really important for us not only to focus on folks who are eventually denied entry or stay in Canada because of excessive demand, but to capture how harmful the whole process is. So for anyone who's being caught under this provision, there are a number of harms that they're going to experience. So if someone gets that warning letter that they might be in excessive demand, in most cases, they have to hire a lawyer because it's quite complex to respond to, which is, of course, more money. If someone is told they might be in excessive demand, that means more months or years in the processing of their application. It means looking at a person just as though they're a cost figure and not a full person with a full life and contributions and value. It means being called a burden in line with stereotypes about people with disabilities and migrants. And if someone is ultimately denied, or if they just can't afford the time or money of challenging the excessive demand finding, it means the lost opportunity of either staying in Canada or entering Canada. There's one thing I really think is important to note, and hopefully I'm not going over time. Why let me know if I am. One thing that's really important to note here is one of the harms we noted is this like negations of any contributions to Canada. So this idea that a person is just a cost. Here, I think it's really important to flag that the solution is not to include that like value that people bring into the equation. First, it's just like there's no way of calculating that, really. Australia tried to do it and ended up backing out because there was no way to calculate it. But more importantly, it's just further dehumanizing. It's telling folks who have health conditions or disabilities that, prove to us that you're worth being here. So it's absolutely not the solution to this regime. Okay. So once step 1 and 2 are done, the government can still say, well, fine, it's discriminatory, but it's justified. So we have to do a bit more work to show that no, it's discriminatory and it's unjustified. So here the focus is really on what does the provision say it does, and whether that in and of itself is, worthy. Oh, sorry. Um, uh, Whether that in and of itself is a worthy justification, and does the provision actually do what the government says that it's doing? So the government, of course, is trying to suggest that this provision is saving our healthcare. It's overburdened. We can't have more people coming in and draining our resources. Well, the Supreme Court has already said that cost-saving measures are not justification for discrimination. So, good start. Importantly, when we look at what this provision does in terms of saving healthcare costs, it's minimal, if that. So the government has already said it doesn't really know how, it doesn't have good data to calculate how much it's saving through this provision. But the best estimates is that it saves 0.1% of provincial and territorial healthcare budgets. Notably, this stat is from 2017. So this stat is from before the tripling of the cost threshold, when there are far more people being denied. Therefore, today, the cost savings would necessarily be lower than this 0.1%. So all that to say, there's very little justification for this provision, even on the best data. So where do we go from here? So as I mentioned, unfortunately, at the end of last year, the case came to an end. The merits were never assessed. The government never responded to our arguments. It came to an end mostly for procedural matters, which was very disappointing. But as an organization, the Legal Network is committed to continuing this work, and we're actively looking for new ways to start this challenge and to hold the government to account. We're also committed to continuing to work with our partners and continue this research, this public education. And if you're interested in being part of these conversations and learning more, the Legal Network just set up a website on medical inadmissibility, and the link is on the screen. And we encourage you to check it out and join the fight. So thank you.
Great. Thank you so much, everyone. I'm the last speaker. So my what I hope to do today is to continue what Anne-Rachelle was just speaking with respect to potential legal strategies that we can employ to overcome the excessive demand policy given its discriminatory effects. And if you just heard, the excessive demand regime fuels society's prejudice and stereotypes against persons living with disabilities. There's no doubt about that. But I think from my perspective, I also want to emphasize the fact that, of course, Valentina made this point as well, that we're not talking about all persons living with disabilities, right? The excessive demand regime specifically targets certain foreign nationals with disabilities and their family. And so, as you've just heard from Valentina's historical recount of how this policy comes to being to its current state, the whole concept of medical inadmissibility, including the excessive demand regime, has a long historical roots in the stereotypes that newcomers are diseased bodies who pose a threat to Canadian society, which must be managed, right? As well as this stereotype that we often hear, and no doubt you've probably hear some of that rhetoric in present day about how newcomers are somewhat of a health tourists who are seeking free and quality healthcare that Canada offers. And so, it's this kind of perpetuation of these kind of stereotypes by the excessive demand regime that I argue ought to also form a part of our analysis under Section 15 of the Charter, equality analysis. Right? So when we argue that this is a regime that's discriminatory, I think that we need to highlight the fact that yes, it's certainly singling out individuals who are persons living with disabilities for the reason that they are living with disabilities. But more importantly, we also need to know that these are newcomers, right? And there are specific stereotypes associated with newcomers that made them susceptible to these policies and made governments, that emboldens governments to put out this kind of policies. Throughout the history of Canada's immigration system. And so the question here that I want to address is, so then how can we, get at this kind of discrimination under the Charter? Right? How can we craft a Section 15 Charter claim that, that can capture the kind of discrimination that I was just describing? Now, as Anne-Rachelle was just mentioning, the HIV Legal Network's Charter Challenge was based on the ground of disability, right, which is an enumerated ground under the Charter, Section 15 of the Charter. Now, what about the newcomer piece, right? How can we get at that? The answer to that question seems more complicated than it meets the eye. The most obvious way to frame that kind of Charter challenge, I would argue, is to go to this analogous ground that has been recognized by our court. That's called a non-citizenship status, right? So in the very first Section 15 case decided by the Supreme Court of Canada, the Supreme Court recognized non-citizenship status as an analogous ground, right? So a ground that is similar to all those grounds that are listed under Section 15, and that attracts discrimination, and therefore we need to protect it. Now, despite the recognition of non-citizenship status as an analogous ground, the Charter's case law over the past 40 years has unfolded in such a way that it makes this ground's usage in the immigration context rather limited. The law has evolved to such an extent that it seems to suggest that immigration law's differential treatment between citizens and non-citizens is generally not considered a breach of non-citizens' equality rights, right? Even though you recognize that non-citizenship status is a ground worth for protection under our Charter equality rights guarantee, but somehow when it comes to the immigration context, that ground seemingly disappears. And that is because in a pair of cases, the Supreme Court of Canada established this general principle that differential treatment between citizens and non-citizens in the immigration context is actually permitted under Section 6 of the Charter. Right? For those of you who don't know, Section 6.1 of the Charter concerns people's mobility rights. Right? It stipulates that every citizen of Canada has the right to enter, remain in, and leave Canada. Right? So to the extent that we're talking about excessive demand regime, which is about a person's right to enter or remain in Canada, but the Charter only guarantees that right to citizens of Canada, the Supreme Court says, well, that's the reason. It's not discriminatory. The Charter only gives that right to the citizen. And that's why when it comes to non-citizens, the government has all the right to treat them differently, right? And so that's not discrimination according to the court. And so you apply that logic, it would seem that to challenge the excessive demand policy on the basis of non-citizenship status would not be fruitful. And I suspect that's part of the reason why the legal network choose not to go that route. So then what else can we do? Right? So another possibility may be to challenge the excess demand policy on a form of discrimination as a form of discrimination based on immigration status. So we're not just talking about non-citizenship status more generally. We're talking about perhaps there's some differential treatment between how different people, different newcomers with different immigration status are treated. So excessive demand policy does not apply to all newcomers. It doesn't, for example, apply to family class immigrants, convention refugees, or protected persons. So for the most part, it applies to, for lack of a better term, economic migrants, right? And so that presents a possibility for us to argue that this differential treatment between different categories of migrants constitutes a form of discrimination on the basis of immigration status. However, to make that claim, we need to establish immigration status as an analogous ground under Section 15. Now, many people have tried this. And so in a vast majority of cases, Canadian courts have said, no, immigration status is not an analogous ground. And the reason was that since immigration status is something that people can change, it is not an immutable characteristic in the same sense as other grounds protected under Section 15, right? So you cannot change the fact that you have disabilities, for example. You cannot change the fact that, you're sex, right? But when it comes to immigration status, yeah, it's something that people can change. And therefore, our court says that this is not a ground protected under Section 15 Equality Rights Guarantee. Now, as some of you in the audience would know, I fundamentally disagree with that judicial stance. I have regularly urged the court to reconsider that position because in my view, to characterize immigration status as a changeable characteristic ignores how our immigration system works. In most cases, a person seeking to change their immigration status will need to apply for such status change and secure the government's approval, right, which the government may or may not grant. So unless the government agrees to your status change, you may very well want to change your status, but the ability to change that status is taken out of you, right? And so I just want to spend the last 2 minutes I have to tell you the latest development on this legal issue, which comes from the Supreme Court's latest decision, just released last Friday, in the case called Attorney General of Quebec and Kanyinda. So the case concerns the constitutionality of Quebec's policy that excluded refugee claimants and only refugee claimants from government subsidized childcare spaces. And now in that case, the majority of the Supreme Court ruled that the Quebec policy was unconstitutional. It violates equality rights guarantee under the charter, but on the basis of sex. So the court ruled that the exclusion of refugee claimants from subsidized childcare disproportionately affected refugee claimant women. As you can imagine, that it impacts their ability to access the job market and worsen their social exclusion, and therefore exacerbating their socioeconomic circumstances. What I found really interesting in that case, though, was the Chief Justice Wagner's concurring decision. So the Chief Justice in that case wrote a concurring decision in which he recognized refugee claimant status as an analogous ground of protection. That was quite major in terms of the legal development, even though it's not part of the majority decision. But now you have one Supreme Court justice that clearly recognized a form of immigration status is an analogous ground. And moving beyond just a simple analysis based on whether a characteristic is changeable, The Chief Justice underscored the fact that refugee claimants are historically disadvantaged group who face a great deal of prejudice, and therefore discrimination based on refugee claimant status goes to refugee claimants' human dignity, right? And I think a lot of what he said in that case could be used similarly to support a broader recognition of immigration status as a ground of protection and not just refugee claimants status. But even if you go to the majority's decision, which again is decided based on the ground of sex discrimination, even the majority in its decision underscored the need to analyze charter equality claims through an intersectional lens. Right? So in that case, Miss Kanyenda, after all, is not just a woman, right? Specifically, she was a refugee claimant woman, and her disadvantage, stems from that specific intersectionality. And so if you apply that to what we're talking about in the excessive demand context, I think Kanyenda is quite, give us some hope, right? We can, first of all, build out what Chief Justice Wagner's ruling tells us about refugee claimant status to potentially ground a case based on immigration status. But even if you just go by the majority's ruling, you can say, well, look, let's continue with a charter challenge based on mental and physical disability, but really pay more attention to the intersectionality, right? How the fact that we're talking about newcomers to Canada actually adds to the disadvantage that people are facing, right? And so I think that, in my view, again, this is a very doctrinal and very legal perspective, but I think there's something that we can build on for the future. And so I will end my presentation here, and we can go into a Q&A, okay, for the rest of our time. All right, so I'm now putting back my hat as a moderator. I see that we have quite a few questions already put in the comment section, so I'm just going to go through them. So there are some questions around exactly whom the excessive demand policy applies. So Anne-Rachelle, do you want to just address that question in terms of the excessive demand policy? Like, I know that I quickly mentioned that in my talk, but which migrant group that it applies and who exempts?
Yeah. So essentially, if you're applying for permanent residence or a visa for more than 6 months, you're probably going to have to do the whole shebang. However, yes, there are a number of exempted groups, including refugee claimants, protected persons, and family class sponsorships. To respond to some of the concern or the questions around like who is a protected person. So this is someone who's either gone through the refugee process in Canada or abroad through a private refugee sponsorship and who is deemed to be a protected person. So this is either someone who is a refugee or who otherwise faces a real risk to their life abroad. And I can't recall exactly when these exemptions were added to the legislation. But it was added because like the humanitarian sort of nature of those claims, it was deemed that they shouldn't face sort of a bar on remaining in Canada, given the risks that they would face if they couldn't, due to a health condition. I hope that answers the question.
If I can add, I think these exempted categories, they were added in 2002 with IRPA, because I do remember that because I was talking about the fact that I was excluded initially, but then IRPA came into effect, and because I'm married to a Canadian, then I was able to be exempted.
You're muted, YY.
Sorry about that. So I just want to follow up on that specific point. I think, you know, I think in some ways we can say, well, right now there's some exemptions afforded to some group of people, right, including refugee or convention refugees and protected persons, whom I think logic would dictate that yes, if you want to offer people, safety, we need to make sure that the safety is not conditional upon whether they actually has disability or face some kind of health conditions. Now, the issue, as I mentioned, is, well, now the excessive demand policy is experienced more by, or impact more by the, has a greater impact on what we call economic migrants. Now, how do we kind of make sure that, how to explain to people that this is still not just justified, right? I think maybe that is something we can talk about. I have some answers, but I just want to hear what other panelists would like to say about that point.
I think there's one thing I'll quickly flag. So when we were preparing the challenge, we made a number of access to information requests. And so we got to see a lot of the government's thinking and analysis behind this provision. And some of the documents were quite clearly making assumptions about people with disabilities' ability to be productive, without really citing to any relevant studies or any sort of proof. Like the government was just making these bold claims of like, well, people with disabilities have a harder time integrating, they have a harder time finding jobs, and none of that is substantiated in those documents. And so I think it goes, the fact that it disproportionately affects economic migrants, I think, really reinforces the discriminatory sort of underlying thinking behind the provision.
Yeah, I also think that it's important to underscore the fact that when we're talking about economic migrants, we're not, like, I think we're not always talking about like some of the kind of the most privileged group of people, right? I think it's it's a category that we use to label a wide swath of people. This could include, for example, somebody who has come to Canada for a long time working as temporary foreign workers, and suddenly now they qualify for permanent residence, and then they might actually get barred at that stage, right? Because of medical inadmissibility or excessive demand policy, and the fact that somehow we think that these individuals are good enough to work on our farms and other places, that we're okay to rely on their labor. But then at the time when they're actually going to apply for permanent residency, we say, no, you're somehow too costly for us to integrate into our society. I think that there's a bit of exploitation going on in that kind of narrative too. So again, I just want to kind of flag that just because we're talking about the impact being borne by economic migrants, like we need to understand that the disadvantage impact of excessive demand on these people are still real, and oftentimes, to me, it's quite compelling that we should not dismiss them so quickly.
Could we hear the voices of people? It's one thing reading the questions up, but maybe people want to speak their questions. It would be nice to see some faces. We've been talking into the screen.
Can I just add something to what I was mentioning?
Yes, please.
Yeah, like I think like what is like I think we need to discuss also like it's how the role that immigration plays in Canada, because there is like a perception that Canada accepts immigrants because it's a nice country and we're doing a favor to immigrants. But if you go through, like as I went through all the discussion that politicians had, it seemed very clearly that like what emerges is that immigration is like perceived at the political level as not this being generous to other, but it's like a right that Canada has to select the brightest and the best that are useful to us. So like immigrants are picked for like the use that they have, because you were talking about it seems a little an exploitation. Yeah, it is in fact an exploitation. It's like this understanding that like Canada has the ability to pick up like those people that they consider valuable.
Precisely. Okay. So I see that there's a question. Oh, there are actually two hands. So I'm just gonna go with the hands and then so I know that Michaela, you have a question in the comments, so maybe I'll go with you first and then I'll go to Melanie and Joaquin.
Yeah, sure. Thank you everyone thank you to all our presenters. It was quite interesting. I'm a student in Professor YY's access to healthcare class at U Ottawa, so this was very relevant to that as well. So my question was, I was wondering if, well, I've read that the application and review process for permanent residency is estimated to be like 40, 50, sometimes 100 years for some applicants, which is obviously, I think, beyond the possibility of waiting for a lot of people. So I was wondering if this has been considered by the courts or I guess by anyone in our legal system as a factor that kind of affects that changeability that they're saying, like people can change their immigration status. So I was wondering if that's been examined or considered at all. Yeah, thank you.
Oh,
So Anne-Rachelle, do you want to go ahead?
Sure, yeah. So, yeah, thanks for raising that. I think bureaucracy is so harmful and we don't talk about it enough. So I'm glad that you brought that up. So recently, like of the applications that I kind of work on for PR, like it used to be 2 year processing, and then within the last year, it changed to like 10. Like overnight, we saw this dramatic increase. And you're right, it's not realistic. It has a dramatic impact on people's lives. And I think we will be seeing in the coming year or so some challenges and responses to that. What I can say is that there are legal avenues, it's called mandamus application, for folks to challenge the length of time that their application is taking. Um, that application is made a bit trickier because it's all to do with reasonable expectations. So historically, like when the waiting time was 2 years, if your application was taking 2 years, even if that was like the most agonizing 2 years of your life, because the government said it's a 2 year wait, this is the average, you didn't really have a basis to make that claim. I don't know what's going to happen now that it's 10 years, etc. And I'm not sure how exactly that plays out when it comes to excessive demand applications. I don't know if a mandamus has been made in that context, but great question.
Right, I'll just kind of add to that. I think, Michaela, you were also asking, to what extent does the court take that, the length of time required to process the case into the consideration of whether immigration status, for example, is something that's changeable or not, right? So in the Chief Justice Wagner's concurring decision in Kanyenda, he did address the question of immutability, and the court said, well, so the Chief Justice said, one reason why refugee claimant status is immutable is because, yes, people can submit an application, but before the application is accepted, during that period of time, they're stuck with that status. Right? And so if you kind of apply the same logic, you can say, a person, they're in the process of applying for PR. But while they're waiting, which, as you said, could be years, they're stuck with that process. So for that period of time, that status is not changeable. And I think that is a very practical and sensible way of understanding our immigration system. Melanie, please.
Yeah, hi. Thank you so much for your presentations. I don't actually have a question, but I just wanted to share my excitement about connecting with all of you. So I'm currently teaching a disability law course at McGill, and I'm not an expert in immigration law, but I'm going to be having a one class devoted to the medical inadmissibility provision. So I've been doing some research, and Rochelle just came across that the denial of public interest standing decision. So yeah, it's just very timely to connect with all of you. Valentina, I've ordered a copy of your book. I haven't finished reading it yet, but I feel like there could be opportunities to collaborate potentially, maybe do some event at McGill to raise awareness about this. And also, I'm talking in my personal capacity here, but I also currently work at the Canadian Human Rights Commission. And I'm just wondering if any of you have ever considered potentially taking like this to the international law stage. I'm thinking, for example, under the UN Convention on the Rights of Persons with Disabilities. So I guess that is a question.
I would respond to that. Hi, Melanie. You're probably a colleague then of Alana Klein at McGill. Yeah, so she's a longtime colleague, and she was hired by the legal network, HIV Legal Network, 25 years ago. Before the mandatory HIV policy was put into place in 2002, she was hired to do a historical legal analysis and a contemporary legal analysis of the what was the initial proposal by the federal government to ban or preclude the immigration of not only permanent residency applicants, but refugees in particular. So she was an articling student with Arbour at that time, and she was hired to do a very, well, it ends up being a landmark piece of research. And over time, yeah, she's collaborated with the HIV Legal Network. And then she's also hosted events on this topic. So I was a postdoc years ago at the Biomedical Ethics Unit, and we put on an event in collaboration with the AIDS Community Care Montreal, Concordia, and COCSIDA. So that was a focus on HIV and health law. But there's this sort of long history with your particular department, if that's the one that you're in, on this issue. So I think that's how it's sort of interesting that historical link that Valentina flags, and then my work ethnographically, right, on the HIV treatment of people living with HIV and the exclusions and what that looks like, including waiting and all the things we're discussing, but that it would be a nice way to continue the collaboration that is actually long, sort of 25 to 30 years old at this point, or lengthy. So we look forward to that.
Yeah, thank you so much. And I'll connect with Alana. So I haven't taught this disability law course since 2017. So I'm a bit out of the loop, but yeah, that's great to know that that relationship already exists, and I'll be in touch with her and hopefully with you.
And on the international possibility, international legal instrument question. So there is a current case, not related to excessive demand, but the case called Toussaint is about undocumented migrants' access to healthcare in Canada. And the case went before the UN Human Rights Committee, and which have found Canada in violation of the International Covenant on Civil and Political Rights, specifically the right to life, by denying undocumented migrants healthcare. Despite that decision, however, Canada has chosen not to do anything. And that's usually part of the problem when it comes to those kind of international human rights instruments. It's how do you enforce it? And there's ongoing litigation now with respect to how we can enforce that Human Rights Committee's decision. And so I think even though this is not directly on excessive demand, I think there's a lesson to be learned there that we can certainly explore the international route as a way of advocacy. Just we need to be mindful of its potential or lack of potential sway on the government, I suppose.
Well, and sorry, just to follow up quickly, I can't commit to the Canadian Human Rights Commission doing anything today, but I know this issue is on their radar because the Commission is actually the designated national monitoring mechanism for the CRPD. And so I know we've raised this issue in our reports to the CRPD committee. So yeah, I mean, it's not a solution, but it's something I think it's important to keep this on everyone's radar.
Great, thank you. We have time for one last question. Joachim?
Thank you so much. My name is Joachim Tamale, and I'm a recent graduate from the Ottawa Center for Health Law with a recent immigration history as a refugee. So I can clearly appreciate all that you're saying and understanding the differences. And just for your information, Prof. Chen was my supervisor, and my area of research was law as a determinant of health. So my point is about, in the discussion, there was an exception that was raised that an exception with medical inadmissibility with regards to protected persons. And what came to my mind quickly was that I don't want to create that debate of who is more vulnerable than the other, but protected persons tend to have a semblance of stability. But my issue is refugee claimants, or the class that we have been referring to as economic migrants or temporary workers. They don't have a semblance of stability. And in such a state of their vulnerability, the worst thing you can ever do to them is to take away their little films of hope to be maybe in a place where they are able to fulfill their work or have a semblance of security. So that actually makes it so important. And that's why I really appreciate all the discussions and everything. Thank you so much.
Thank you. Right. So any person on the panel would like to give the last word before we wrap up today?
Well, I can just thank everyone, and I think this is a very important topic. Again, not just because numerically, the people that are affected are that many, but just because it says a lot about what we as a society, what kind of set of values we have, what we want as a society be. And there is a lot of discussion these days about Canada being committed to be an inclusive society, being open to diversity, and yet it has still policies on paper that are so exclusive, that reject some people. So I think this is part of a larger conversation. Is not affecting just few people that cannot enter the country, but affects all of us, whether we are here, whether we are Canadian citizen, whether we are permanent resident, when we are it doesn't matter, it affects who we are as a community. And so I think it's very important that we communicate this, because there is so much ignorance about this piece of law. There is very few people that are aware of it. And so I think it's important to bring it to the forefront. So thank you, everyone, for being part of this conversation with us.
Well said. Thank you so much, Valentina. And thank you to Laura and Anne-Rachelle for joining us today. And thank you all for being with us. And just a reminder, please fill out the survey if you can. The link is in the comments. And thank you. And we look forward to seeing you in our next webinar, whenever that is. All right. Bye, everyone.
Bye, everyone.
Bye. Thank you.